Hi, everyone, and welcome to the seminar, The Rise, Crisis and Resilience of International Courts from the Hague to New Global Hubs. Today with us is Mikael Madsen. He's a professor of law at the University of Copenhagen and director of iCourts, the Danish National Research Foundation Center of Excellence for International Courts. His research focuses on the globalization of law, examining how international courts, legal elites, and transnational networks shape global legal orders and authority. He has studied and conducted research at leading institutions, including the École des Hautes Études de Sciences Sociales in Paris, Oxford University, and the University of California, Berkeley. His work explores the role of legal institutions, expertise, and professional power in the process of global integration. Through his teaching and scholarship, Madsen contributes to advancing legal sociology, the theory of legal profession, and the study of law's globalization. Thank you. I give you the floor, Professor.
Thank you. Could I have my slides up there? So the talk is called The Rise, Crisis and Resilience of International Courts. It's a very long title, and I've even shortened it from the one I gave you before. It's long because it has to cover a 100-year period. And from the very first international courts created in the beginning of the 20th century to the latest developments in international courts. So it's really about the emergence and rise of international courts as a particular institution of global governance. The growth of that institution and the eventual expansion and crisis of the very same institution in recent years. And finally, it's about a little bit what is happening at the very frontier of international justice, how the space of international law is changing in these years and is challenged by new geoeconomic and geopolitical transformations. So all this is what I'll try to wrap into this talk, which is about 40 minutes long or something that order. So there's no doubt that the international courts have increasingly become a part of global governance. This is both a new and a very old development. So when I was a law student, which is many years ago, there was only a handful of international courts. You could practically read all the decisions of like the European Court of Human Rights. That would be impossible today. Today, there are at least 25 international courts, depending how we define them more specifically. And there's certainly indications that there could be many more. There's for years been a discussion of an international environmental court. There's also debates about an international climate court. There's now very intense debates about an international space court. And then there are old ideas related to a truly international human rights court. And then, of course, perhaps the most hotly debated, the Special Tribunal for the Crime of Aggression against Ukraine, that's also being debated and possibly set up as we speak. So there are, first and foremost, more international courts, that's beyond any doubt. But international courts are not just proliferating, they are also becoming more prolific. So we have counted there must be something in the order of 65,000 judgments from international courts across the globe today. And more than 90% of those have been issued over the past 2-3 decades. So it's old, but it's also recent in some ways. They are not just more courts quantitatively, they are also qualitatively more active in many ways. So what we can see is that over time, most international courts have compulsory jurisdiction, meaning that states are obliged to use them. Many international courts today allow other agents than states to initiate litigation before them. That is, that individuals can bring cases before them, like at the European Court of Human Rights. And finally, and of course most controversially, a growing number of international courts have the authority to review state compliance with international treaty commitments, which in some cases effectively make them into some kind of international constitutional courts. So it's all these processes about the proliferation and how the courts have become more prolific that we've been studying at my center at iCourts in terms of the origins and consequences of these transformations. And it's also the processes I will focus on today. But to do that, we'll first go back in time. So the role that international courts can be said to play in global governance today started to take shape in the beginning of the 20th century. We can, of course, if you dig enough historically, of course, you will find something, and you'll find that there has been discussions of courts since the 14th century about international courts. And the first real international court was the one up there on this slide. It was the Central American Court of Justice, which was created in 1907 and worked until 18 from Cartago in Costa Rica. It was a short-lived but interesting case for understanding how international courts originally, in part, grew out of ideas related to federal courts, yet how this took new forms. This court was created against the backdrop of a number of failed federal projects in Central America after independence, most of which followed essentially the boundaries of Central America laid out by the Spanish conquistadors as the Kingdom of Guatemala. But this court was vested with very extensive competences. Not only did it have international jurisdiction for interstate cases, it also allowed, actually, and very few know that, individuals to access court, and it even had competence to rule over separation of power conflicts at an international level. No international court today has that power except the Central American Court of Justice, number 2, but that's another matter. So in this sense, this court, in a unique way, links, if you want, constitutional law to international law. It's faced many problems, as you see in the slide. The first one, there was an earthquake on the left that wiped it out. Go back to the slide. It wiped it out, and then it was in Cartago. Then it was moved to the Casa Maria on the right. And if you've been to Costa Rica, you know that's where the Foreign Services of Costa Rica in San Jose. But soon after, tensions arose between the member states, and partly because the US had a heavy hand in the construction of this court. So it heard 10 cases during its first 10 years of operation, and then it essentially expired under what you call a sunset clause after political rift. Of course, it will come back. We'll get to that. So in a way, you could say it was not until 1922, with the establishment of the Permanent Court of International Justice in The Hague, known as the World Court, in the wake of the devastating war, that the first real international court came into being. If you look at this court, the first thing you notice when you look at the architecture is, of course, it looks something between a town hall and a church, but we're not going into that. No, if you look at the travaux préparatoires, as we do as lawyers, and also if you go a little bit beyond it and look into the diplomatic mail related to the drafting of the World Court, you realize that the construction of this institution was an exercise in fumbling in the dark, because there was no clear agreement about who the court should decide over, how it should decide, who should be the judges, how they should look, and not the least when the opening hours of the court should be. As you know, when it's winter in the south, it's summer in the north, and when it's night in the south, it's the day in the north. So it was in a way a temporary construction. The basic claim I'm making is that what they were facing was not just a challenge of creating an international court, but in reality, what they were facing was to put into legal language how international society should look like. And remember the world in 1922, where you have is strongly marked by large empires. The empires in question at this point is, of course, the British and French, and then the emergent ones like the US. And then the well-meaning smaller states, such as where I come from, Scandinavian states, Latin America, Spain, and so on, that were trying to get some kind of influence in this. But what was not evident was where the line should be drawn between essentially raw imperial power and the notion of peaceful coexistence of public international law. So the court became, as is often the case in diplomacy, a compromise. So the permanent court hardly lived up to its name. It was not compulsory and far from permanent in a modern sense. Its decisions were essentially depending on the will of the member states. But one question seemed to riddle the proceedings of this court more than any others, and that was the very definition of an international judge. Because it's a very good question. Who should, or even who could, be appointed to act as chief justice of sovereign states? If you look again into the travaux préparatoires, you realize that diplomats argued this is a job for diplomats. The international law professors involved, they had long been sort of the avant-garde of this whole enterprise, of course argued this is a job for international law professors like ourselves. And finally, then there were some people that more cautiously argued, maybe it's a job for judges, or like Supreme Court judges that could be sent to the international realm. The first bench of the International Court was a combination of all these three categories: law professors, diplomats, and actual judges. And it's interesting to see as an effect of what you call past dependence, that most international courts to this day are marked by a similar distribution of competences, in the sense that there are practically a third diplomats, a third law professors, and a third judges sitting on the benches. But things got even worse in negotiation, because the question is, how should they look, these judges? They eventually settled, as you know, on some dark robes, but a proposal that they should wear some kind of little hats led to an outcry from the British, arguing that it would make them look like, and I quote, a cross between bishops and clowns. Of course, if you've ever seen an English judge, this is what the French call la folie de grandeur. But of course, that is missing the finer point of what was going on. Because this was not a question of vanity, but really the sign of the very real birth difficulties that international society was facing in the beginning of the 20th century. And part of the problem of defining an international court and its judges was the fact that the definition of a national apex or supreme or constitutional court was hardly universal. As a matter of fact, the institutional arrangements of the state in 1922 was not as stabilized and settled as we often take for granted today. So the mere fact that, for instance, Hans Kelsen had not invented his court yet in Vienna, and the Supreme Court was still sort of in the making, had the negative spillover effect on this court, that it was in a way unclear what an apex court was vis-a-vis society and politics. What happens in practice was that the law professors on the bench took the lead for the first decade, with a very clear sort of internationalist agenda, and it went surprisingly well. Those of you who teach public international law will know that we still teach some of these cases, Wimbledon and so on, as landmarks of international justice. But then in the 1930s, the diplomats on the bench start getting an upper hand, and the balance tilted towards what you can call a greater consideration of national interest. And then it all started going downhill. Of course, this can hardly be attributed to the diplomat judges on the World Court. The political crisis, of course, that hit Europe at the time, and eventually the rest of the world, and led towards the Second World War, exhibited very clearly the fundamental weaknesses and even powerlessness of the World Court and the League of Nations when faced with real power politics. So the lesson learned at this very moment is that the judicialization and even legalization of international society faced its first major blow in the breakout of the Second World War. But if you have read Karl Marx, and I'm sure you have, you know that history repeats itself twice. So in the aftermath of the Second World War, a number of states decided to create an international organization, this time the United Nations, and an associated World Court, which in 1946 became the International Court of Justice in The Hague. Can you click one? One more click. Thanks. And the International Court of Justice was, of course, largely a continuation of the World Court, but under a new name. But what's interesting is that very soon after, there would be a difference. Because if the World Court in The Hague, particularly in the 1920s, had been the avant-garde or vanguard of the development of international law, in the post-war era, the real drive for establishing a new international legal order with the help of international courts came from somewhere else. And quite paradoxically, it came from Europe, the very Europe that had been at the heart of the Second World War. There is an interlude, and that's indicated on the slide up there, with the war crimes tribunals set up in Nuremberg and Tokyo, which undoubtedly were important symbols of the international community's new sense of justice and would later inspire important developments in international criminal law in the 1990s. But my argument is it was in Luxembourg and Strasbourg that the foundations were laid for modern international courts. In other words, it was under the auspices of the European Community, at the time the Coal and Steel Community, and the Council of Europe, that the models were first devised and tested. Can you click? So to make a very long story short, I would argue it was the innovation of supranational law by European jurists and politicians that provided a new political and legal tool that had the double effect of both providing more power to the international supranational institutions and simultaneously ensuring that the national levels of law and politics were only increasingly deeper integrated with the supranational level. And as this model, in a way, demonstrated its effect in post-war Europe by, most of all, the pacification of Europe, and also the associated economic growth of the post-war period, it is perhaps not so surprising that the templates for further development in international courts, to a very large extent, became the European Court of Justice and the European Court of Human Rights, both set up in the 1950s. And it did not become the International Court of Justice in The Hague. So if we follow the evolution of international courts, and can I have a click up there? In the 1960s, there's really nothing going on. And this is in part due to the fact that two European courts are only just coming into operation, and they haven't really made any stamp. But we get another click, we go into the 1970s, we see the first other courts appearing. We see the setup of the Inter-American Court of the Human Rights a few years before that, the Benelux Court of Justice. And you click again, we also get the Andean Tribunal of Justice. And all these courts, in a way, follow more or less the blueprints of the two European courts. And according to one scholar, Karen Alter, the Andean Tribunal and the Benelux courts are essentially clones of the European Court of Justice. The Inter-American Court of Human Rights, I'm sure some of you know that quite well, in some ways resemble the original European Court of Human Rights. And it's also true that the Vice President of the European Court, René Cassin, was involved with the setting up of the Inter-American Court. But really, the boom in international courts in the 1990s, and get a click here, after the end of the Cold War, and you see really a growth of international courts. Perhaps most strikingly, there's a series of international courts being created in Africa, of which most somehow resemble the two European courts. That is sort of the Common Market Court for East African states, COMESA, the Court of West African Economic and Monetary Union, WAEMU, and other significant developments on the African continent. It's also during this period that two new global courts are created, respectively the International Tribunal for the Law of the Sea and the World Trade Organization's appellate body. And not the least, there's also the reappearance of international criminal law with the war crimes tribunals for Rwanda and the former Yugoslavia, both of them in the late 1990s. If we go into the next decade, the 2000s, we see a similar growth of international courts in Africa, two new courts in Latin America, as well as notably the creation of the International Criminal Court in The Hague, which integrate the experiences from the existing war crimes tribunals. The International Criminal Court was soon baptized the World Court, echoing another court created 80 years earlier. It's of course highly misleading because the ICC is not about states' liability, but personal liability of those in command, and does as such not signal a continuation, rather a significant new development of judicialized international law in itself. If we stop up here for just a second, now we have the map. We have to face a basic analytical problem that we always face as lawyers when we analyze something at an institutional level, because we can observe similar institutional developments, but of course it doesn't mean that institutions are developing in a comparable way. So one way we can explore the differences between the courts is, of course, to use some very basic statistics, counting the number of judgments of different international courts. And can you click again? So if we take all the little dots up there and we multiply them relatively with the number of cases they have, then we see that the European courts grow quite enormously. Can you click that? Actually, this is then the relative size of the European courts to the rest of international courts. And one court that strikingly expands is the European Court of Human Rights. And as we all know, only a few years ago, it had about 100,000 cases pending, which was down from 165,000 cases a decade ago. And if we go deeper into it, can you click again? We take some evolution in the cases of the European Court. This is it's until 2010, but what we can see is very obvious. It's a fairly recent phenomenon. And go back. and it's linked to the opening of the permanent court, the protocol number 11 court in Strasbourg, and of course, a massive enlargement of the jurisdiction in the post-Cold War era. So the question is then, does this growth rate we see in Strasbourg, is that followed by other international courts? And if we compare all the other international courts, where we exclude the European courts, then we get the next slide. And you click, yeah, thanks. So here you see the development of all international courts. And this is a data set I have from my friend, Professor Karen Alton. It looks similar. It's just that the zeros on the axis on the left are a little bit different. Here they're in the hundreds, and the other ones in the thousands. But what is interesting on a general level is that the curve of growth of international courts very much resemble the one we also find in Strasbourg. So this very strongly indicates that the boom of judicialized international law is a recent phenomenon, and one that signals a change from an original international legal order to a more global order, marked by a markedly growing activity of notably regional international courts. So I said 90% of the total output of these courts has just been delivered in the past two and a half decades. And this has impact in many ways. And the claim that we have made at the iCourts, it has impact on both law, politics, and societies. Because what actually you could see on the map before is a striking trend towards establishing international courts in major areas of human life. It's obviously the economy in terms of regional and global trade regulation. It is freedom in terms of international human rights, and it's punishment in terms of international criminal law. And all of this enforced by specialized international human rights courts. If you have read a bit of Foucault, you would know that if you added the military and tax to freedom, punishment, and economy, you have the history of the state. But these are, of course, areas of regulation once essentially associated with the state and national policy, and now they are increasingly the subject of global regulation and the jurisdiction of an ever-growing number of international courts. Can you click? Oh, yeah, thanks. At face value, when you listen to this quick account of the proliferation of international courts, you might sit back with the idea that it's a story of sort of a progressive realization of international courts, because essentially they went from close to nothing to becoming a global phenomenon, starting with interstate conflict resolution in Cartago in Central America and The Hague, to an increase in regional international courts. You might also add that it's a global phenomenon in particular parts of the world, because there's not an even geographic distribution in the map that I drew up before. At a purely geographical level, international courts are mainly in Europe, Latin America, and the Caribbean, and Africa. Of course, many of the Europe-based international courts are global courts, such as the International Tribunal for the Law of the Sea in Hamburg, the International Criminal Court in Hague, the appellate body of the World Trade Organization in Geneva, and of course the Court of Justice in The Hague. But in other regions of the world, we don't find international courts. North America was close with the NAFTA agreement, but its replacement by President Trump, the US-Mexico-Canada agreement, only has ad hoc dispute resolution attached. In the ASEAN integration system, we also find extremely weak dispute settlement mechanisms that clearly favors good offices over judicialized means. And I could go on about many other parts of the world. If you look at the story I told you, there's also, you might say, a suspicious European influence. Many international courts are somehow modeled on European courts, as I've indicated. Some might even say or ask the question, well, this is a European idea, or even a global universal one, even a westernization of international justice through international courts. At a simple institutional level, this seems plausible, and there's no doubt that the European Commission is the biggest sponsor of regional international courts in the world. However, as we have shown in countless studies, even though the institutional blueprints resemble, the actual social, legal, and political embedment and trajectories of international courts are highly regional and local. And just remember, there are many things that resemble each other in the global age: universities, hospitals, schools, militaries, tax systems, constitutions, and so on. But that does not mean that they perform or operate similarly. So one thing that the international courts do have in common, and we have seen that across the globe, is that they are in a way very fragile institutions. They are all contingent on the continuous support of the member states in multiple ways. Member states obviously signed the treaties bestowing international courts with their formal legal competences, and they negotiate the treaties which change those formal legal competences. They pay for the budgets and guarantee the budgets. The member states propose the candidates that are eventually elected as international judges, and member states implement the judgments of judges, or they don't implement the judgments of international courts. So there's no doubt that member states are important as concerns the authority of international courts, but at the de facto level of authority, it might be a little different story, and that's what I'll turn to. Because there's a little bit of advertisement there. As we have demonstrated some of our research, the actual authority of international courts cannot be reduced to simply a question of member state engagements. Because it turns out in practice, international courts are also dependent on our constituencies to gain authority. This includes litigants pursuing these venues by bringing cases, which requires that they have sufficient knowledge of the venues in the first place. It requires lawyers willing to invest in new and sometimes uncertain legal venues and institutions. It requires law professors who systematize the knowledge and the law of jurisprudence of these institutions. It requires civil society engagements of sorts, typically by specialized NGOs or bar associations, and sometimes broader segment society are also immobilized with regard to international courts. So what I'm trying to say is, in a way, to provide an answer to the central question in this regard. Namely, what is it that explains that some international courts are highly active, creating an important jurisprudence that totally defines an area of law, while other remains idle, they don't do much, and don't manage to cast a larger shadow of rule of law within their area of jurisdiction. So if we are to understand the relative differences in power of international courts, we need to be able to answer these fundamental questions. So therefore, we need to be able to understand, how do international courts gain power and authority before we ask the other question that everyone is asking, namely how they lose international authority by state backlash and other forms of resistance. So let's dwell on this just for a second about the authority of international courts. You just go back. So what I'm suggesting is that the actual authority of international courts, what I would call the de facto authority of international courts, is established through its engagements with its major constituencies. So different from its de jure legal authority, which is a formal set of competence bestowed on international courts through treaties, de facto authority is the empirically observable adherence to international courts and their judgments. And we can illustrate that. Now you can click. Just one click. So the first figure here claims authority because the person is authorized. So it's a formal competence bestowed on the person as an authorization as a doctor. This is the case of the medical doctor, could also be a lawyer. I can just click once. And here you have the lawyer claiming, claiming authority on the very same grounds. But then we click one more time, a third scenario, which is well known to people like us, university professors. Here, the formal authority, the professorial power and authority, is questioned by the constituencies of the lecturer, the students, asking questions. So to claim authority, someone has to accept authority, because otherwise it goes nowhere. To illustrate, when I tell my son to go to bed every night, it's a test of authority and has a binary outcome. Either he goes to bed or he doesn't. It's a test of de facto authority. I have ways, of course, but so to go into that, of course. But in a nutshell, the argument is that the actual authority of the authority figure needs to transform from the formally bestowed competences to empirical acceptance of those very competences. If the doctor and the lawyer on the picture up there does a terrible job, they might still be formally authorized and bestowed formal competences, but clients will no longer trust them. They will eventually lose de facto authority, even if they might manage to keep their formal authorization. So translated into the situation of international courts, courts can be formally authoritative by treaties, providing them with various powers, but be weak in terms of de facto authority, because there's too little buy-in from the relevant constituencies, both the immediate ones and the more distant ones. That also means, theoretically, that we can depict de facto authority of international courts as the degree to which different constituencies accept their authorities and take meaningful steps to follow the judgments of these courts. This figure that looks like something you use for shooting is an attempt at depicting three levels of authority of international courts following the analytical logic I'm sort of introducing now. In the very middle, we have what we call narrow legal authority. And that's when you have international courts when only the parties to particular disputes accept the authority of the court and take meaningful steps towards compliance with the court's ruling. The court's authority obviously remains very limited in this case, because it doesn't really extend beyond the litigants to the dispute. This might sound like an absurd situation for a court, but it's actually quite real, and we'll find it in many international courts that is known to very few. Then we go to the next level, what we call intermediate legal authority. That's when those other actors also start to accept the court and its rulings. The audience in this intermediate range of authority would include potential future litigants, as well as government officials charged with implementing international rules as interpreted by the court. There would be executive branch officials, administrative agencies, and national judges. Obviously, when we move to this sort of intermediate level, court's influence becomes more consequential at this stage. Then we go to the next circle, the extensive authority. And that exists when an international court expands its circle of recognition to encompass a broader range of actors affected by international court rulings. This audience includes their court sort of immediate compliance partners, but it also extends to civil society groups, bar associations, firms, industries, legal academics. So international courts with extensive authority can consistently shape law and politics for the legal issues that this authority encompasses. For example, the two European courts, the European Court of Justice and the Court of Human Rights, both have such extensive authority. The Inter-American Court of Human Rights would arguably also have such a more broad authority. The reason I'm introducing this is because that to address the question everyone wants to address these days about backlash against international courts, you need to know how authority is constructed in the first place before it's laws. And using this analytical framework actually allow you to do one thing. It is to understand that authority can change over time across issue areas and member states, and you can analyze it in a much more, if you say in English, a piecemeal fashion. So different from most studies that assume that courts have or have not authority, basically in a binary sense, we try to understand how it is a complex of interactions with the court that construct the authority. That also means, and this is where, the political scientists, they die when I say this, it also means that an international court can have de facto authority even though the member states are against it, because all constituencies might very well support the court and adhere to it. This is what we found, for instance, in some African courts. The member states are basically doing sovereignty politics. They are avoiding the courts, but the civil society are engaging the courts and therefore creating cases that might not be complete compliance with those cases, but they gradually make the courts perform and transform them over time. It also means that some courts can be highly authoritative in one moment and not in another. That's, of course, where you start looking into the criticism at international courts. As you know, there's been a lot of writings about this, and I was very surprised when people started writing about this, how quick they were to jump to the conclusion that it was the end of the international judiciary. Of course, there are many cases to look at if you just click one time. It's a little faded slide, but it was just to give you some examples we used when we studied this systematically. Of course, we had in North America, Donald Trump, number 10. He opposed the World Trade Organization's tablet system by economic starvation and blocking the election of judges. Russia at the time institutionalized that judgments of European courts should only be complied with if they complied with Russians' values. In the Caribbean, Trinidad and Tobago left the American Convention of Human Rights because of their the whole quagmire over death penalty. In Brazil, there was these long-going skirmishes with the Inter-American Court over the amnesty laws. And in Africa, we had the infamous situation where the Tribunal of the Southern African Development Community was suspended after delivering basically its first decision. These are historic examples, but of course, we could provide many more from the contemporary situation. What we find is that international courts might be impaired and impacted in various ways by backlash politics towards them. But we also find it is extremely rare that they are closed down, such as the Tribunal of the Southern Development Community. There are two reasons for this, according to our research. The first one concerns the very nature of the critique of international courts, which is actually that it's a legal critique. It's not an institutional critique. It is a disagreement with the direction of the jurisprudence. Where I'm from right now, the government is very mad at the European Court of Human Rights for its judgments about expulsion of foreign criminals under Article 8 of the European Convention. But they keep maintaining they like the court. They just don't like the jurisprudence on Article 8 and some on Article 3. This is important because there's a fundamental difference between when politicians and others set aim at the institutions or the jurisprudence. It is what we in an article have called the difference between backlash and pushback. And actually what we find systematically when we study this, it is only very rare that states set aim at the very institutional setup, of course. There's a second reason that backlash is not very often leading to the demise of international courts, which is because of counter mobilizations, and which involves both other member states and the kind of constituency I talked about before. If you look at it, backlash is most often unilateral action. As a multilateral action is quite rare. And that has legal consequences, namely because single nations cannot dismantle international organizations like courts. They can hurt them organizationally, financially, but they cannot alone bring them down. In that sense, ironically enough, multilateralism provides a protection against onslaughts on multilateral organizations. The European Court of Human Rights is a very good example of it. Moreover, since multilateral action is rare, there is ample space for civil society organizations and law professors, bar associations to counter-mobilize against attacks on international courts. And in reality, what we find when we have studied this systematically is that it's precisely what happens. So you have the pushback or backlash against international courts, but very soon after, we see that these other constituencies come into the picture and start defeating the backlash. So why is that? Well, it is precisely for the very reasons I gave you before, that because of if de facto authority of international courts is constructed through its various engagements with states and other actors, the losing of that authority must also happen through engagements with those very same actors. So that means that the courts that have only very narrow, limited authority are far more fragile than the ones that have an extensive authority. It seems obvious, but in practice, it has significant consequences. So the courts that has been impaired institutionally, if you take it systematically across the globe, are the ones that suffered from not having more extensive de facto authority. So that means that courts like, for instance, the European Court of Human Rights, that has this extensive authority, sits far more robustly within the European legal space than many other international courts. I think on this positive note, I will close just clickwards.